Look, in that case, already I have filed IA, my lord, for implement of the private respondents, my lord. Can it be taken tomorrow, my lord? Already filed on 30th of.
Yes, yes.
May I please, your lordship, my lord, I beg to mention for listing of a pending writ petition, my lord, regarding demarcation of my land, my lord. And there is an interim order passed, but despite of that, my lord, some construction works are going on by enforcing my land, my lord.
You filed an IA.
No, my lord, for the. that-
You want a order restraining them from construction.
If my lord may.
I am giving the order today. In a
My-
pending matter, this order is not possible unless you file an
My
IA.
lord, my lord,
You know how it is.
my lord.
You want the order today or listing permission?
Only for listing, my lord, of the writ petition, my lord.
But I will dictate the order also.
No, no.
Prayer is rejected.
My lord.
You have to file an IA, you
My-
know how it is. Yes, file it and then make a motion.
Oblige.
May I please your lordship? Lordship, I beg to mention item number 4, lordship.
Hmm.
My engaged counsel is out of station for his father illness. Kindly adjourn the matter.
As paid for by the counsel for the petitioner, this matter stands adjourned for a week. Yes.
May I
1
please,
week.
your lordship? Lordship, beg to mention one IA for
Yes,
Step-
Mr. Gogoi.
Item 4 was fixed.
Yes. They want time. All right.
Okay.
Mr. D. Gogoi, Learned Standing Counsel, Forest Department Assembly is present on behalf of the respondents. Yes.
May I
Yes.
please your-
Yeah, Lordship, beg to mention one IA for stay vacating, your lordship, maybe on 5th or 6th, your lordship.
6th.
Yeah, please,
Another IA for implement, your lordship.
6th.
Oblige.
I beg to mention item number 14, lordship, supplementary cause list.
Yes.
Lordship, D. Talukdar is not well, therefore kindly matter may be adjourned for the day. She is suffering from illness.
Item number,
14, supplementary cause list,
you are for the petitioner.
lordship.
In the prayer of Miss.
Peter, I'm at Talukdar.
You are
Peter at Talukdar.
Miss A. Talukdar, Learned Counsel for the writ petitioner made with the consent of the opposite party. This matters, admission hearing of this matter stands adjourned for 2
Lordship,
weeks.
interim continue. Interim may be continued,
Interim
lordship.
order passed earlier to continue.
Please, lordship, they are for listing a WBC, lordship, for admission, lordship. Lordship,
When do you want it?
next Thursday, lordship.
Why? What is the urgency?
Lordship, some illegal construction carried out upon a private route, lordship, upon a public route, lordship, by the private respondent, lordship. Lordship, the level of the road become higher, then my petitioner's residence goes, lordship, down, lordship.
So what order you want?
Lordship, for admission, lordship.
We'll have it after vacation. What is the urgency?
Lordship, the drainage is also, lordship,
But without filing an interlocutory application, now an interim order will not be passed. You have to file an interlocutory application.
no, lordship.
Then file it. Yes.
Item 1.
Yes.
They have to permit for holding of the election.
In this respect, we have got the instruction. So as per my instruction, already a verification application has been received, in response to which the district commissioner has sent it to the superintendent of police for verification. And from the verification, it has been found out that no such meeting ought to be allowed because some civil case was pending. So I have the details about this. The permission hasn't been granted for the sake of change of name.
No, but how is the district commissioner and SP concerned with all these things?
Because
This is an
one,
internal matter of the organization.
because 144 was being imposed.
When was on 144 imposed? What is the date? When was 144 imposed?
144 is invoked, for a long time.
You have not challenged that.
No, 144, how can you tell? We want, this is normally done in political cases that they do not give permission. But in respect of a society,
Mr. Das, please.
144, how can you tell it?
When
in
was
pub-
144 invoked?
It is in public interest, they have done it. But a
You
permission.
are not
for-
helping the court to pass an
Fine,
order in
fine.
your favor.
Yes.
You can make your arguments.
Fine.
We'll post it for hearing
Fine.
after puja. If that is what you want, it's
No,
fine.
no, I don't want, my lord.
I am asking you, when was the 144 imposed?
My lord, the date, I don't have the date.
Because these orders are in force for
Particular-
2 months.
2 months. Yes, that should be-
So has the 2 months already passed?
I think so, my lord, the 2 months is gone.
Has it been extended?
My lord, they will have to take instruction because date of the 144 is not. to me.
That's not clear.
Let it come at 2 PM, my lord, I will inform.
2 PM none again. I got it.
After some time, my lord, he will take instruction, my lord. Civil case has nothing to do with, civil case says don't change the name, we are not changing the name.
If your lordship goes to Annexa B, the last page of my instruction,
Is there any status quo order, restraint order from
No.
the civil court?
No,
there has to be because
Oh,
I have
to be
annexed the
what?
order, my lord.
the reference has
Is,
been,
is there an order or not? I am asking you, what are you saying?
the
has to be?
reference has been brought as regard the title suit case number of 50 of 2023. The order of 27,
So
2020.
there must be an order.
There has to be an order because
That
that,
is your instruction as
Yes,
a
yes.
government advocate.
no, lordship, that is.
Let the SP come. Let
No,
him
Lordship,
appear on Friday.
that copy hasn't been so furnished to me. So that
We
transpires
have
from,
granted adjournment
let-
twice for
let-
obtaining instruction
No,
and this
I'm-
is the instruction. you
let
have.
it be after 1 hour. Let me
Right.
be clear about
All
this
right,
particular
after 1
order.
hour.
Yes.
Otherwise, we would like to
Page
interact with
42, I
the
have
SP.
annexed the
Yes.
order, my
On
lord.
what basis he is doing this verification? How is he bothered? If there is a status quo order, then we can understand.
Because reference
you-
has been brought as regards.
I have annexed the order, my lord, page 43.
Let him, after 1 hour, we'll take.
Yes, I have
Yes.
annexed the order. They are saying that don't change the name. We are not going to change the name.
With your lordship, madam, this matter came already with your lordship, my lord. Junior took time to find out whether any similar order is there, madam. This is regarding, madam, the fixture of the taxes on the market, madam, fees. On part broiler chicken, my lord, they have fixed rupees 7 rupees per broiler, madam. So that we have checked,
Who? They means who?
madam,
Who
that
has
is panchayat. Panchayat. Already they are in order, my lord, they just take your lordship to page 27. Government has already taken an order, my lord, page, my lord, it is 22. That already your lord kind of page 27. Section 25 to page 45.
And where is the impugn order?
Don't kindly see my page, my lord, your lord, page 17 kindly see my page. Because when it was allotted to Mohalda, he started charging fees, my lord, of rupees so and so. We've had an application saying that he cannot do it, my lord. So this is the application. In a response to that, my lord, the impugn order was passed.
Which page is the impugn order?
Impugn order is page, my lord, 19. Page 19, along with the chart. Your lordship vernacular is page 20 and 19 is the English translation line. And chart is your lordship will find page 21.
Yes, Mr.
My lord, the petitioner cannot rely on this notification which is there at page 27
Hmm.
because this notification is pertaining to suspension of levy
Hmm.
for setting up of business activities, for setting up a new establishment. His is not a new establishment. His is already existing in nature.
Hmm.
He cannot.
So, panchayat living tax under which entry in the constitution?
Section 25, my lord.
Section
Page
25.
25.
Let's see.
This order was issued on 25 surplus 6, my lord. Surplus 6.
His is already existing. It's not his case that he's going to establish a new shop.
Okay. 25 surplus 6, man.
25B, my lord, first.
25B.
B,
Yes,
Panchayat has the power to impose tax on
that's
trade.
true. That I am not denying. But
So this impugn notification is issued under 25B.
My lord,
No.
Let him-
And 25(6), which he is relying on, is operating on a completely different field.
Yes,
That is,
so let the commissioner, principal secretary decide whether this imposition
My lord.
is in accordance with law and pass an order.
completely policy decision.
Till such time, no coercive action, that's what we'll say.
But excess, my only, question, I have given some additional affidavit
Hmm.
to municipal board, I have given, madam,
Sorry?
some municipal board that they have also might impose some taxes.
Hmm.
So that I have given, my lord, it is per shop per day, my lord.
Hmm.
Now they have, what they have done, it is per chicken per 7 rupees per day, per chicken. It's a daily market, my lord. So my
Alright,
poor,
let
poor
the-
traders, my lord.
Let the principal secretary examine your given and pass an order. Till
Or
such
let them
time-
file a representation and time may be given to the secretary to
My
dispose
lord,
of
we have
within
filed
3
to the
weeks.
CEO, my lord, and CEO in response to that, he has issued this notification.
All right, until it is disposed of, no coercive action. Heard Mr. H.R. Chaudhary, learned senior counsel, assisted by Mr. So-and-so, learned counsel, appearing for the.
It is shocker.
Eti Shankar. Also heard Mr. P. Handy, learned standing counsel, Panchayat and Rural Development Department, Assam, appearing for the respondent numbers.
3, my lord.
Respondent number 3, Ms. H. Barua, learned government advocate, Assam, is present on behalf of the respondent numbers. Why not 1? You are not representing the principal secretary Panchayat.
My lord, I am.
Huh?
1.
Then why are you saying 3?
Sorry, my lord. 1 as well.
1 and 3. Ms. S. Barua, learned government advocate, Assam, appearing for the respondent numbers 2 and 4. None has appeared. 2 and 4. Stop. The read petitioner hearing claims to be read petitioners hearing claim that they are involved in the business of trade in broiler chicken, within quotes broiler chicken, assailing
In the
the
Dolgao daily market, man.
broiler chicken from a shop located in the
Dolgao daily market.
daily market. Stop. Aggrieved by the notification dated 28/8/2023 issued by the respondent number 3, thereby imposing and oblique or enhancing the tax on broiler chicken up to ₹7 per chicken sold.
Not chickens.
The instant writ petition has been filed, inter alia contending that the impugned notification contravenes the government notification dated 25/4/2022 issued by the respondent number 1, exempting imposition of any tax or fee upon activities, including that carried out by the writ petitioner. Full stop. In support of his argument, Mr. Chaudhary, learned senior counsel, has invited the attention of this court to the provision of section 25(6) of the Assam Panchayat Act 1994 to contend that once the government has issued a notification suspending levy of any tax or fee, the Zilla Parishad would not have any authority under the law to issue notification imposing fresh tax. First up, Mr. Handy, learned HCPNRD on the other hand submits that under section 25(b), it is permissible to impose tax on activities connected with ongoing trade, and the impugned notification dated 25/4/2022 only relates to setting up of new business. Full stop. Be that as it may, from a reading of the notification dated 25/4/2022, it is not clear as to whether imposition of taxation on ongoing business activities such as the one carried out by the writ petitioners would also come within the sweep of the notification dated 25/4/2022. Full stop. Unless there is clarity in the matter, it may be difficult for this court to pass an adjudicatory order in this issue, in this matter. As such, but this writ petition is being disposed of by granting a week's time to the writ petitioners to file a representation before the respondent number one, ventilating their grievance in the matter. If such representation is filed within a week by enclosing a certified copy of this order, the same be looked into and be disposed of as expeditiously as possible, preferably within 6 weeks thereafter. Until such time, a final order is passed by the respondent number one on the representation to be submitted by the writ petitioners. No coercive action shall be initiated against them for recovery of tax under the impugned notification dated 28/8/2023. With the above observation, the writ petition is disposed of.
My lord may, in his discretion, reduce the time frame to 3 weeks. My lord has given him 6 weeks.
As expeditiously as possible, you do it.
As
within 3
expeditiously as
days,
possible. my lord.
Yes.
Obliged.
I can say.
but not later than 6 weeks.
But this was connected with item 4. Same area, same reserve forest.
You have the instructions.
I have those, last date I had said, my lord, that these issues were canvassed in certain other writ petitions, whereby, my lord, those claims are rejected. Those petitioners are seeking, my lord, allotment of forest lands in their name, my lord. This is slightly different because they have a possession right
Well, we'll take it up next week and.
together with.
None appears for the writ petitioner when the matter is called up. It appears that this matter is tied up with item 4, case number debo, which has been adjourned for a week. Mr. D. Gogoi, learned SC Forest Department, Assam submits that he has received instructions and is ready for conducting motion hearing of this matter. Be that as it may, since the learned counsel for the petitioner is absent today, register to list this matter along with item 4 in the next week for motion.
Hold it.
For additional item 5, along with item 13 in supplementary list.
May I please, your lordship? Your lordship, this is a case related to the matter of eviction, my lords. My lords, this is a case wherein the petitioners have Pradhan Mantri Awas Yojana house, which is sanctioned by the government over the land. This is the case wherein no notice was served on the petitioners in that aspect, and they were being asked to evict within 2 days. So therefore, we have, my lord, in earlier, while filing this petition, we have only implemented party as only the revenue department and also only the deputy commissioner. However, my lord, since this is a central government scheme which sanctions the houses, the construction of the houses, therefore, my lord, it is necessary that all the parties who are responsible for Pradhan Mantri Awas Yojana, for implementation of the Pradhan Mantri Awas Yojana scheme should also come into the picture, should also be implicated as a party, so that their view could also be understood. Because what happens, my lord, Pradhan Mantri Awas Yojana house is a fully sanctioned government scheme, and therefore, my lord, it's a one-time process. A Pradhan Mantri house, once it has been given, can be never given again, my lord, according to the framework for
No,
implementation.
1 minute. Who are the petitioners here? How many petitioners are there?
Total 15 petitioners, my lord. Few of them have Pradhan Mantri Awas Yojana houses.
1 minute.
Yes, my lord.
Don't be in a hurry. Then the order will also come in a hurry. Then
My
you will
apologies, my
regret.
lord.
Yes. Why are they before this court?
My lord, because, yes, my lord, that is very important, my lords. What happens that, my lord, they were being, on a fine day, they were being asked by the circle officer to evict the land. To evict the land, my lord.
Ask means by orally.
Request, yes, my lord. That's very important, my lord. I'll bring to that aspect, my lord. My lord, may kindly have their affidavit, my lord. It was our case that.
Acha, you take your seat. Let me understand what is the case. You are completely confusing the court. You are not presenting your facts. You are jumping into your conclusions.
Yes, my lord.
I am asking you, what is your case?
My
Tell
lord,
me the facts first.
facts,
Yes.
is, my lord, that we have been staying in a government land since 20 years, my lords. They said it's a government land, my lord. But however, we have their Pradhan Mantri Awas Yojana houses over the land, my lords, which in the fully government section houses, my lords. Now what happened, my lord? If my lord, they come, my lord, I'll present this case, my lord. My lord, kindly have our petition, my lords. kindly have a petition.
Hmm.
In para. My lord, para 2 of our petition.
Yes.
My lord, in para 2 of our petition, which says that the petitioner are much aggrieved and aghast with the action of the circle officer of Naharkatiya circle office, who is threatening to evict the petitioner without reliable reason, prior notice, or any kind of notice, my lords. Now, my lords, to that, they have replied in their affidavit. My lord, kindly come to para number 4 of their affidavit, my lords, which the respondents have filed, my lords. My lord, they have said that the averment made in the paragraph 2 of the writ petition are incorrect, hence denied by the answering deponent. In this regards, the deponent states that the petitioners who were encroaching government land covered by DAG number 45, 44, 55, and 56 of the government DAG in Nagaon, Hojuapathar village were requested to evict from the said plot of land. My lord, I want to stress on the word request. My lord, my humble submission is that I don't want to submit or suggest the fact that I've never seen any circle officer requesting a person from marginal society to evict the land. But however, my humble submission is, what does request mean in the realm of law? Because, my lord, there are ample case laws by coordinate bench, and my lord, from your lordship also, where lordship have authored judgment. I also question the jurisdiction of the circle officer. My lord, in this regard, I want to present a judgment. My lord, this is a judgment by the coordinate bench. My lord, kindly may come to para 7 of the judgment. My lord, it says in the above circumstances, notice dated 29/5/2019 under Rule 18 clause 2 of the rules under Assam Land and Revolution Act 1886 has been issued against the petitioners, requiring them to vacate the encroached governed land that they are occupying. My lord, this case stands on a better footing that no notice had been issued. However, my lord, in our case, they have said that we have requested. My lord, then it is on para number 8. If my lord comes to the third line, it was contended by the petitioners in this case. It is provided that even the street hawkers, my lord, has it? In this case, my lord, what I mean to say is that, my lord, it was stated that the circle officer doesn't have any jurisdiction to evict, to issue a notice of eviction. However, my lords,
So there is no order, there is no notice issued.
do notice, my lords.
Hmm.
And my lord,
So
I want
listen.
Yes,
You have come to the court apprehending eviction.
apprehended. But however, my lord, in their affidavit, they have admitted
Hmm.
that they have requested us to evict. Because, my lord, our
Requested you to vacate, not
Vac-
evict. You are not going to evict yourself.
vacate, my lord, which
Hmm.
in a matter would become eviction.
Hmm.
But however, my lords, my
You are occupying the land by constructing houses under the PMGOSI. What is that?
Pradhan Mantri Awas Yojana Gramin scheme, my lords. Which
That
is,
money has been given from there.
yes, my lord, everything has been given, my lords. Even the scheme has been implemented.
So how you have constructed house on government land?
Yes, my lords. Yes, my lords. I want to take, my lords, to the regulation of the Pradhan Mantri Awas Yojana scheme, my lords,
Hmm.
for a minute. my lord, may kindly come to page number 19, given on the below, marked below, my lord.
Page number 19.
Page number 19 of the framework for implementation.
Yes.
My lord, if my lord may see the clause 5.2.2.
Hmm.
My lord, it is stated that in case of landless beneficiary, the state shall ensure that the beneficiary is provided land from the government land or any other land, including public land, in brackets, panchayat common land, community land, or land belonging to other local authorities. For the selected land, educated infrastructure, visa, electricity, road connectivity, and availability of drinking water, solid and liquid waste management facilities may be ensured. Thereafter, my lord.
So before constructing house with the funds provided by the PMAYG scheme,
Yes, my lord.
do they not inquire about the title and ownership of the land? That is not done.
My lord, it is being that's the important thing, my lord. Therefore, my lord, it is being all regulated and monitored by all the nodal authorities which have implemented in the my lord, interlocutory application. In 5.3.2, my lords, on the same on the page number 20, my lords. My lord may come to the 6th line. In case of landless households, the state shall facilitate registration of land in the name of woman or jointly in the name of husband and wife, except in case of widower, unmarried, separated person, transgender. So, my lord, the framework for implementation of PMAYG houses says, so, my lord, this is a scheme which says that house for all, which is envisaged by the central government and the Prime Minister of India, which says that there should be house for all. That will be reduced to house for some when, my lord, the state government evicts us from the land. Because this is, my lord, a one-time process. But however, my lord, my humble submission would be that before going into the merits of this case, my lord, a very important settled law, my lord, I want to, because my lord also has authored a judgment, Tahir Ali, where my lord has held. Therefore, my lord, on the issue, whether a notice has to be issued or not, my lord, is in consideration before the division bench. My lord, there is an order to that effect. When your lordship has was presiding over a division bench, my lord has made that order. It's in recent order of 30 June 2023, my lords.
All right, so what is your submission?
My humble submission is that, my lord, since they have not issued any notice, and we have bona fide right over the land, which we will prove by submitting our affidavit. But before that, my lord, there's an unsettled law, that is whether a notice has to be issued or not, because many coordinate benches have decided that some, my lord, in Tahir Ali had said that Audi Ultram Partem PNJ has to be followed. However, in Bimal Chandra Das, they have said that, my lord, notice has to be mandatorily issued. Therefore, this is an unsettled law. And as per division bench, we humbly submitted, my lord, our case is one of the cases which should be heard along with, my lord, Salakuddin, to decide on this issue of notice has to be issued or not. Because, my lord, in my humble
So what is your response to the statement in para 4 of the affidavit?
But we have to file our affidavit. We have to file in response to their affidavit, my lord. But however, we'll file that. But however, my lord, before that, no notice has been issued, my lord. The people will.
If supposing notice is issued,
Okay, my
say
lord.
court orders notice is issued, what will you say?
My lord, we have our bona fide claims over the land, my lords.
What is that claim? Tell me that.
Since, my lord, Pradhan Mantri Awas Yojana houses have been built over the land, my lords.
Yes. Anything else?
That's my submissions, my lord.
Lordship, out of my instruction is out of 15, only 4, page 67 of my affidavit. So all the repetition is different cause of action. So only 4 who are beneficiaries of this Pradhan Mantri Awas Yojana scheme, page 67. So Hajua Pothar, Bipul Gwala, Kusumi Sonwal, Birbal Gwala, Mohan Karia. These 4, they have got the benefit of that scheme. And thereafter, lordship will kindly come to page 68. Let us take the example of number 2, Kasumi. So she has submitted an affidavit because before we are requesting them, of course, right, lordship, we are requesting them. Otherwise, we could have used the bulldozers also, which we are not doing.
Sorry, sir.
Lordship will kindly see the affidavit. I, Kasumir so-and-so, I have been in possession of a land measuring so-and-so, covered by DUG number, government DUG number so-and-so. This is true that now I apply for allotment settlement of aforesaid government land by authority concerned for construction area. She has applied for a separate plot of land, which was passed by the district level state land advisory committee. That was done prior to the scheme was, this particular work was allotted. The work was allotted sometime in the month of November 29th last year. And on 26th, the land advisory committee allotted separate plot of land for all the persons who will be affected by the construction of the stadium there. No notice was given. It is not required under the regulation. And also it was known to them. And as a result, they have agreed that they will shift to the other plot of land. And for that, the government has already completed the exercise for demarcating and handing over the possession of that land. We have annexed all the photographs. If Lordship is pleased to come to page 138. And most of them have already started construction of houses there. Page 138. Adjacent land. So this particular plot of land is required for establishing a sports complex there, and there is greater public interest involved.
Who all have started constructing houses?
Yes,
there?
Lordship, these are the photographs, and Lordship will see the
No,
officials.
can you please point out from the petition, which petitioners have started?
Only 4 petitioners were there having houses in this particular plot of land from where we want their relocation. Basically relocation.
Only 4 petitioners?
Only 4 petitioners. And if Lordship directs, whatever amount has to be given under the scheme, we will give them from the contingency fund.
And others did
Others,
not get any?
in fact, they have given the affidavit. All of them have given the affidavit. It is to their knowledge. Now they cannot turn back before this honorable court when they have agreed before the authorities concerned at that relevant point of time when the affidavit was made. It was made on 22nd/9/2022.
Just a minute.
All the affidavit.
Let me see the affidavit. Affidavit is page?
Page, Lordship, 68, that is a translated copy. And the original copy is at page 71 in Assamese, vernacular.
Yes, let us see 71.
71 is in Assamese, Lordship. And the translated copy, may I read the translated copy? Lordship?
Yes.
That I have been in possession of a plot of land measuring 1 katha 10 lasas covered by government DUG number so-and-so at Hajua Pothar Gaon under Moza so-and-so. It is true that now I apply for allotment of settlement of aforesaid government land before the authority concerned for construction of a house. I hereby declare that I do not own and possess any patta land other than the aforesaid plot of land in my name anywhere in the state of Assam. My husband name is so-and-so. He was a daily laborer. He has also no patta land. I declare that aforesaid land is under my possession and it is true that I wish to construct a house thereon. I am a woman belonging to ST. I will be abided by all rules and regulations of the government for allotment and settlement of the aforesaid land. So we have given them alternate land within the same DUG.
All of them?
All of them, Lordship. Apart from this petition, others persons were also there. And apart from this,
And what is the land equal amount? What they are?
In fact, they were actually, they had no right over they were encroachers in government land. Now we are giving them 1 katha, which is permissible under the land revenue regulations and the land policies of the state. And that has been approved by the state level, the district level committee, which we have stated in our paragraph. Lordship will kindly come to paragraph 10, page 63. May I read it?
Page 63.
Page 63, paragraph 8. And also paragraph 7, we have stated, with regard to the top first line, with regard to the averment made in paragraph 6, the writ petitioner concerned as per PMAYG beneficiary details of Hajwapar, only 4 beneficiaries of Hajwapar are standing on government land. Now paragraph 8. The proposal was considered for construction of mini stadium at Nagaon, Rajohua, Khel Pothar, Naharkotia, LAC Dibrugarh. For construction of the stadium, a large area of land is required. Accordingly, land measuring 30 bighas covered by Doug number 44, 55, and 56, situated at Hajua Pathar under Jaipur Moja, has been selected for allocation of stadium. On physical verification, it is found that some portion of the land has been under unauthorized occupation of some persons. After negotiation, the opponent have agreed to vacate the land if they were given land settlement in a nearby locations. So there was a negotiation. After that, proposals for settlement of land to the occupants were prepared as per procedures along with affidavits, which in point number 2 of the said affidavits submitted that the petitioners, it is stated that the land will be used for residential purpose by constructing a house. Thereafter, the proposals were sent to the subdivisional land advisory committee for recommendation. The proposal was recommended in the SDLAC meeting held on 26/9/2022. The deponent stated that the administrative approval has been accorded by the Public Works for the stadium on 27/9. So before the official administrative approval for the stadium, the land was already given through a procedure, which is that meeting held on 26/9. Next page, Lordship. The deponent and work has been allotted on thereafter by order dated 30/11/2022, the construction contract has been awarded to Ganapati Constructions Company, Guwahati. The deponent states that by order dated 21/1/2023, the LR staff of Naharkutia Revenue were assigned to show the new land recommended for settlement to the beneficiaries of Hajua Pathar Gaon under Jaipur Moja and to demarcate the same. The road and drain development work at the new land settlement area has been carried out by Jaipur Development Block. Even after demarcation of land to each beneficiary and developmental work of road and drain in proposed settlement site, one family and 9 others started part construction, but all have not shifted to allotted site. The certificate to that effect is at Lordship. Page 134. Issued by the Block Development Officer, Jaipur Development Block. This is to certify that a drain cum road scheme and the land development scheme, namely land development of Gerua Pathar, Hajua Pathar, new residential colony drain, so and so, have been taken up under MNREGA scheme on the land allotted to the people affected for construction of mini stadium at Nagaon, Naharkutia. The said schemes are still in ongoing stage. So we have done our best so that the public interest is also solved and the private interest is also not adversely affected. So our status is very clear, and in paragraph 4, we have very categorically stated, paragraph 4, Lordship, page 62. In this regard, the deponent said the petitioners who were encroaching government land covered by Doug number 44, 55, and 56 of government Doug in Nagaon, Hajua Pathar village, were requested to evict from the said plot of land and were informed that separate plot of land else would be provided to them, but the petitioners neither followed the instructions of eviction nor they cooperated in discharging duties by the officials of district administration who were present at the site. Paragraph 5. In this regard, the deponent stated that petitioners were residing in No Hajua Pathar for last 20 years is not supported by cogent evidence. It is humbly stated that only 6 number of petitioners have merely submitted copies of Aadhaar card, voter ID. Rest of the petitioners have not submitted any evidence whatsoever. So basically 4 persons who were beneficiary of the this scheme, PMAYG scheme, and only their land is not also given to them. They were given the benefit for construction of house. If they have really completed the work, Lordship, that observations may be made, because the stadium should come up, and Lordship has held in that same judgment which my learned friend was indicating. And regarding circle officers jurisdiction also, Lordship was pleased to consider in Tahir Ali's case. The judgment was delivered on 26th September 2019. We have extra copy, Lordship. Regarding circle officers' role, this is Lordship judgment. Paragraph 9.
Yes.
By producing a copy of extraordinary gazette notification dated 6/2/2010 issued by the Department of Revenue and Disaster Management, Government of Assam. Mr. Saikia further submits that the Assam Land Revenue Regulation Amendment Rules 2009, the power conferred upon the Deputy Commissioner under Rule 3 of the rules frame under the Land and Revenue Regulation has been vested on the circle officer as well. Therefore, he submits that the contention that the circle officer did not have just jurisdiction to issue eviction is untenable in law. By referring to the pleadings, etc., now Lordship will what into submission. And yes. No, very good. Then the circle officer of power to. Now coming to paragraph 15. From the above, it is clear that the amendment provision of 18(2) of the settlement rules does not mandate issuance of any notice upon persons coming in the ambit of said sub-rule. The petitioner are admittedly in unauthorized occupation of her Sarkari khas land, and it is evident from the materials on record that they do not have any bona fide right of claim over such land. Such being the position, there were no requirement under the settlement rules for the authorities to serve any eviction notice upon any of the petitioners. Notwithstanding the same, the respondents have served notices upon the petitioners granting them 15 days time to vacate the land, thereby complying the principles of natural justice. Rule 3 of the settlement rules deals with delegation of powers of the Deputy Commissioner as per the pre-amended provisions of Rule 3, Sub-Rule 2. Such power of the Deputy Commissioner could be delegated not only to the subdivisional officer, only to the subdivisional. However, by the amendment carried out on 6/2/2010, circular officer has been added in Sub-Rule 2. Therefore, after the aforesaid amendment, the power to take action under Sub-Rule 1 and 2 of Rule 18 can now be delegated to the circle officer. Since the Deputy Commissioner has not disallowed the notices issued by the circle officer, delegation of power under Rule 3, Sub-Rule 2 upon the circle officer can be reasonably presumed in this case. In such view of the matter, the plea of want of jurisdiction as raised by the petitioner does not come for acceptance by this court. And paragraph 19 and 20. It is no doubt correct that India being a welfare state, the government would have constitutional obligation to promote welfare of all its citizens. However, a welfare state must serve the public interest at large. Article 21 of the Constitution guarantees to all its citizens protection of life, and such protection would undoubtedly include the right to live with human dignity. Therefore, it will be the bounden duty of the government to protect such rights of the citizens. To that extent, it would be open for the writ petitioners to approach the state for providing them with alternative land in accordance with policy followed by the government. Precisely, we are doing this. However, the petitioners cannot, as a matter of right, claim any right for allotment of government land, nor can such plea be taken as a condition precedent to vacate unauthorized occupation of Sarkari land. The concept of welfare state and the right of the citizens under Article 21 must receive a harmonious construction so as to protect the larger interest of the state and its people. Therefore, the concept of welfare state cannot be expanded to such extent so as to recognize the right of encroachers to continue in unauthorized occupation of Sarkari land, as such a recourse would go against the public interest. No person can claim to have indefeasible right either to encroach upon or to continue in unauthorized occupation of any government land. Therefore, when a process of eviction of encroachers is initiated by following due process of law, the writ court cannot interdict in such process so as to protect illegal occupation of encroachers upon government land. What would, however, be significant to note herein is that regardless of the provisions contained in settlement rules, principles of odi alterim partem rule must be complied with in all cases involving removal of encroachment from government land, so as to give a reasonable opportunity to the unauthorized occupants to vacate the land under their possession. In the present case, the respondent have admittedly complied with the rules of odi alterim partem by serving them evictions notice upon the petitioners. From the reasons stated above, I am of the view that no case for interference with the eviction notice be made out. In our case, Lordship, no notice was issued. But from the exercise, that submission of the affidavit by them when alternate land was given to them, which they have accepted without and that affidavit was not done by force, by any force or any coercion. That is not their pleaded case also. So in that situation, Lordship, we are giving them an alternate land, which is adjacent to the existing plot, because we need contiguity in the plot of land where the stadium has to be constructed. It cannot be in parcel wise. So there should be a continuous plot of land so that a proper ground, proper galleries and public parking, etc., which is not being there in that particular area in Naharkotia, Lordship. So the greater public interest demands that a stadium should come up there. And those persons who are illegally encroaching, the government is kind enough to give them an alternate. What is happening in Silsaku? Same story, Lordship. For public interest, we want to have a natural reservoir so that a part of the water logging can be saved in Guwahati or checked. So in that situation also, Lordship, another coordinate bench said that no notice is required. There also, we are making an effort to give alternate land now. Already compensation is being given. 5 lakhs to the persons who are having RCC buildings, those who are having thatch house a little bit lower. And also an effort has been made to give Lordship alternate plot of land also. That exercise is also going on. But so far as the present case is concerned, the instant case which is before this honorable court right at this moment, alternate land has already been given to them.
All the petitioners.
All the petitioners, let them come up, indicate one that who has not got.
And you
And
say
only in case of those persons, 4 persons, which we have indicated, if they have really constructed the house by spending the money of 1,50,000, which they have got under a scheme. If Lordship directs, we are going to provide them that amount also. Or in case of these 4 persons.
No, Mr. Saika, I appreciate your arguments in almost all counts. But please address the court on one aspect.
Lordship.
Those who have constructed a house, they have put in these are poor people. These are not very affluent people.
Lordship.
So would it not be reasonable to compensate them a little bit if they are?
I leave that to this honorable court. I cannot say anything because it will be taken as an example for other cases. If Lordship feels that there is an appreciation that 1 lakh, because I have seen the date of the scheme beneficiaries, it was given in 2019, the latest one. Other one was 2018, if I'm not wrong, page 63.
Where is that list you have just shown?
Yes, page 67. So one beneficiary was of 2019, then one of 17, 3 of 2019 and 1 of 2017. Kasumi of 2017, Vipul Gwala, Birbal Gwala and Mohan Kharia 2019. And house status is shown as completed. Last column.
So let us take it that they are to be compensated for the
Lordship.
house. What is the principle which will be correct? What principle is to be followed? It can't be done.
The FDR rate maybe 6% per annum above whatever amount they have received under the scheme.
And others don't have any house standing there.
They are going to construct house. And they are not all beneficiaries. They are not beneficiaries. So they will have to put their own money. But they will get a land in their name now. Because SDLSC has given the approval. In fact, everybody was agreeing. How they have turned around, we do not know. This is my humble submission, Lord.
If I may, my lord, with due respect to my senior colleague, my lord senior colleague has taken through the affidavit, my lord. My lord, first of all, prima facie, you want to submit that we are from very marginalized society. We don't want to come on the way of development in no manners, my lord. It is my unconditional instruction from my client that they don't want to come into development. However, my lord, a bona fide case should be presented before this honorable court. My lord, I want to reread the affidavit which has been presented by my senior colleague. My lord, please come to their affidavit on para number 5, my lords. With all due respect to my senior colleague, my lords. They said that the averment made in paragraph 3 of the read petition are incorrect, hence denied by the answering deponent. In this regard,
Mr. Boragohai,
Mr. Burman,
Mr.
Manas Burman, my lords.
Manas Burman.
Yes, my lords.
Okay. You see, first question is, you have not filed a rejoinder to the affidavit.
We will do, my lords.
Oh, sorry, I'm disposing of the matter today. You see the last order, it was clearly mentioned there.
It was already dismissed once.
No, my lords.
No. This matter is being taken up for final
My
disposal.
lords, we will do in a short accommodation, we'll do it, my lords.
Absolutely sorry. You see the order dated 29/2023.
I understand, my lords. We
I'm
will,
disposing of this matter.
no, my lords. We are young counsel, my lord. We'll do it 1 week's time, my lord.
Sorry. That
My
I will
lord,
record.
please give us short accommodation, my lord. Will not even take 2 days, my lord.
That's
my lord.
not possible, Mr. Burman.
My lord,
This
will not even
this
take 2
writ
days, my
petition
lord.
was restored on a condition
My lord,
that they, listen.
yes, my lords.
The court has a duty to be fair to both sides.
Yes, my lords.
It was restored on a condition that the matter will be finally disposed of.
My
It was written in the order that parties to come prepared, it will be disposed of.
my lord, we are.
Question of granting you time does not arise.
Mm.
If you go on insisting on that, I'll close the matter and
My lord,
dictate.
I'll just take two things I'll bring to the attention of my lords.
You do it.
My lords, in,
Now, before that, please answer to 3 questions.
yes, my lords.
How many of the petitioners have constructed house?
My lords, there are 4 people. However, my lord, what happens is that
Attendance.
my
Yes.
lord, there are 4 people who have constructed the land over the house. There is also, my lords, Indra Awas Yojana house by another person.
Listen, the point is what the learned advocate general is saying,
Yes, my lord.
that all the petitioners are being allotted land, thereby, listen,
Yes, my lord.
creating right in their favor in the adjacent land. And those who have constructed houses, they will also be paid compensation. But the land is required for construction of a stadium. Without this land, the contiguity of the plot will be broken and the stadium cannot be constructed. You are also saying that your clients are not coming in the way of development of public infrastructure.
Yes,
So
my lord.
what really is the issue here?
The issue here is, my lords,
Hmm.
we were not kept in, my lord, the problem here is it's eviction versus land acquisition. My lord, the question is this, my lord, I want to read their affidavit in page number 68, my lords. Please come to their affidavit 68, my lord.
Yes.
What happens, my lord? We are from the government land. Our government promises us that we will provide you the land, you provide the affidavit. My lord, please come to the affidavit in page number 68, my lord, in 1. He says that I have been possession of plot of land measuring 0 biga 1 katha dos lesa 10 ls covered by Dag number 44 at Hojua Potar Gaon under Moja Jaipur. That it is true that now I apply for settlement of aforesaid government land before the authority concerned for a construction of a house. My lord, this is Kusumi Sonwal who has Pradhan Mantri Awas Yojana house. My lord, in para numbers 7, they said I will be abided by all rules and regulations for government of allotment settlement of aforesaid land in my name. It is, my lord, this land which I'm talking about in this affidavit, which has been misread, my lord, to say that we have been asking for settlement of a different land. But this has been misread before this honorable court with my humble submission, my lords. And my lords, this happens so because if my lord notices all this, my lord, vernacular affidavits are all in the same handwritings, my lords.
Okay.
My lord, what has happened that the reason why I did not, in my humble submission, my lord, why I did not submit this affidavit in response because, my lord, there are additional affidavit that has to come, my lords.
All right.
One thing I'd like to clarify, the alternate land is also under the same DUG. Same DUG. That's why there is same DUG number.
My lord, if that
This is a big vacant plot of land.
Well-
And alternate land is adjacent what I am saying, but within the same DUG numbers. That is why the affidavit is indicating the DUG number. There is no indication regarding what is in the left side, right side, all these things. Boundaries are not demarcated.
But just because you responded, you have to make the allotment of the land first.
Yes, Lordship. For allotment, the state level advisory committee or the district level or subdivisional level land advisory committee must give the approval. That has already given.
No, my lords.
Page 129.
All right. But the
It is
orders
recommended,
of allotment.
Lordship will kindly say page 129. That will clarify
My lord,
everything.
it's recommended, not approved.
Lordship will kindly see final list of allotment settlement proposal of so and so Nahar Kotia revenue before SDLC held on 26. So this was approved. In our affidavit, we have said this is the total list, how many persons were approved. Not only the writ petitioners, there are other persons also.
So we are concerned only with the writ petition.
Yes, Lord, if the writ petition, all are included here.
Let him conclude. Yes.
My lords, my humble submission on this case would be two aspects, my lord. First of all, my lord, we have been kept in complete dark. Only after the writ petition came, we knew that such thing as DLC has happened. Because, my lord, this affidavit was procured from us because they say in the affidavit that it was prepared. Was on 22 September 2022. The SDLC meeting happened on 26 September 2022. On the very next day, the approval came.
Mr. Burman, you have not been able to answer one question of the court.
Yes, my lord.
You are saying your clients do not want to come in the way of development
Yes,
of
my lord.
public infrastructure.
Yes, my lord.
So what is your proposal?
Our proposal is, my lords, that
They shift the stadium somewhere else.
no, well, we be compensated appropriately, my lords. We be let the affidavit come that.
So you don't want land?
Yes, ma'am. In
Land and compensation and house and a car,
No, my lords. We don't have
some
such big claims, my lords.
foreign travel tickets.
No,
something
my lords. I'm sorry if I have indicated that in some way, my lords, but however, it's not our submission. And my lord, I'll just request a week's time, my lord, we'll file the affidavit in week's time failure, which
No,
my lord,
that I
this
will not do.
petition may be
You
disposed of,
take
my
it
lord.
up in other forum if necessary. The order is very clear that it will be taken up.
My lords,
This court will always stick to the schedule,
my
Mr.
lords,
Burman.
please accommodate us, my lord.
Sorry,
My lord,
that's
1
not
week's
possible.
time, my lord, we'll
Order
then
is
the
up.
affidavit may
Yes.
come, my lord, that
Highly
they
obliged.
propose.
When the court says we'll take up the matter and such and for disposal, this court will always do it, except for medical emergency. There is no respite from there. This is a question of credibility of the court. We'll not change it. Why did you not file your affidavit?
My lord, my humble apology.
You had
my lord.
more than 10 days time.
My lord, we humble apology, my lord. We have to file the implement of
All right,
parties, my lord.
You file it. You file it.
My lord, we'll file it, my lord. Give us, my lord, 1 week's time, my
All
lord.
right, let's see. I'll
For
see.
orders item 6.
Next matter, please.
Deeply obliged.
Much obliged.
Yes.
May it please your lordship. This matter, the steps that were required to be taken, we have taken. Dusty also we have taken. There's a, I think, report, office report note there. Earlier order says that it already steps have been completed. Or your lordship can fix the matter for admission hearing.
For admission.
Because we have given the Dusty steps are completed.
Any affidavit has been filed?
Affidavit has been filed by one of the parties. Your lordship.
Respondent number 3 is
Respondent
filed.
number 3 has filed yet.
No, affidavit of Dusty service on 1, 2, and 4.
No,
It is there.
Dusty service we have filed. And in fact, affidavit also has been filed by one of the respondent number 3 has filed.
Okay, you take down heard Mr. Y.S. Manan, Learned Counsel appearing for the writ petitioner. Also heard Ms. S. Borua, Learned Government Advocate Assam, representing the respondent number 3. Respondent number 3. None has appeared for respondent numbers 1, 2, and 4. By inviting the attention of this court to the affidavit dated 15/3/2023, Mr. Manan submits that Dusty service of notice as per the order dated 10/2/2023 passed by this court has been completed on respondent numbers 1, 2, and 4. Whereafter, an affidavit has also been brought on record. Stop. I have perused the affidavit and I am satisfied and I peruse the affidavit. Full stop. I am satisfied that service of notice by means of Dusty can be deemed to be completed on respondent numbers 1, 2, and 4. In view of the above, register to verify as to whether any counsel has entered appearance on behalf of the said respondents and thereafter list the matter in appropriate column after 2 weeks.
Much obliged.
For hearing item 7.
Yeah, our matter too.
May I please, your lordship? See,
This is petitioner
Matter to him, United.
before he has a library established in the year 1961 lordship. And since then it is running lordship, and in the year 1962 lordship, annexer to page 13, that land over which this was established was kept reserved for the library lordship, annexer to page 13 lordship. Yes, lordship. Thereafter, in the year 1986, that then Deputy Commissioner wrote a letter to the Secretary Revenue Department for settlement, allotment of that plot of land in the name of the this petitioner Putibhal lordship. That annexer 3, page number 16 lordship. And thereafter, lordship, by the annexer 4 in the year 91 lordship, the Deputy Secretary Government of Assam,
Which is the notice you are challenging here?
annexer 7 lordship, page 22.
What is wrong with the notice?
As we are not the encroachers over that plot of land, as already that was process of allotment was going on, and that was reserved for this Putibhal. Before issuing this notice, lordship, there's no notice was served on the petitioner, lordship.
All right, we'll dispose it of by, you serve notice and let them present their case.
Lordship, we had filed our affidavit, lordship back. Lordship may peruse.
Yes. No notice was,
Lordship may peruse paragraph 8 of the affidavit filed by the respondent number 2 and 3, lordship. May I read, lordship?
yes.
That with regard to the statement made in paragraph 11 of the writ petition, the defendant begs to state that in compliance with the order dated Honorable Court passed on 9/11/2005 in WPC number 6813/2002, lordship. It has been directed that any authorized person encroaching public roadside land and the land previously reserved for roads shall be evicted forthwith. Rules does not provide for issuance of any notice before the eviction under Rule 18(2) of the settlement rules under Assam Land and Revenue Regulation 1886, lordship. That Kundorgaon judgment, lordship.
All right, but we'll still direct them to hear them. Give them an opportunity to present their case. Thereafter, take further action in the matter.
And
Because
lordship,
it is not a private individual, it's a library. It's a library, and he is saying that already there is a proposal for allotment of the land in favor of the petitioner. So let them present it. Heard Mr.
A. Boron.
But
A.
lordship,
Purwal,
lordship-
Council appearing, yes.
lordship, in paragraph 5, it has been stated that the writ petitioner has claimed are not occupying the area of land measuring 2 kotha 3 lesa
Ms.
under
Hajarika,
Sarkari
all I am
Dam-
saying is, there are two options. Either I allow the writ petition matter ends forever, you can't touch them.
Yeah.
Or hear their grievance and take further action.
Lordship.
Which do you want to do? Which one?
Lordship, second one.
Second
lordship.
one, then take your seat. That's what I'm doing, yes. Hold your breath for some other occasion. Yes. Heard Mr. A. Burwa, learned counsel appearing for the writ petitioner. Also heard Ms. G. Hazarika, learned standing counsel, Revenue Department, Assam, appearing for the respondent numbers. Respondent number 1, Ms. S. Burwa, learned G. Assam, has appeared for respondent numbers 2 and 3. Full stop. The writ petitioners herein. Now, the writ petitioner number 1 herein claims to be, what is the writ petitioner number 1? Is it a society or What is it? A library is not a corporate.
It's a registered lordship society. And XR
Petitioner
one.
number one claims to be a registered society under the
Registered under society.
Societies, what is the Societies Registration Act 1860, check the nomenclature. And the petitioner number two is the president of the said society. Full stop. The petitioner number one society is operating a library by the name of, within quotes, Lakshminath Bezborua Puthi Bhoral, unquote, in the district of Borpeta, Assam, full stop. Aggrieved by the eviction notice dated 7/7/2012. The petitioner has approached this court entirely contending that the petitioner number one is operating a public library over a plot of government land, but there was a proposal for allotment of the land in favor of the petitioner number one society. Full stop. However, when the said process was in progress, the impugned notice dated so and so 7/7/2011 bracket annexure 7 bracket 2 was issued, directing the petitioner to vacate the land within 15 days, failing which there will be forcible eviction. Hence, this writ petition has been filed. Full stop. It appears from the materials on record that the petitioner number one society has been in occupation of a plot of land measuring 2 kathas 3 lechas covered by dag number 1622 of village Sahar Borpeta under Moja Borpeta in the district of Borpeta. The plot of land is admittedly a Sarkari land. Full stop. Therefore, unless there is allotment of the land in favor of the petitioner number one society, it would be open for the revenue authorities to seek its eviction. However, before doing so, since the library has been established over the said plot of land and has been operating since past several years, the petitioner number one society would have a right to be heard in the matter, more so since there is a claim made by the petitioners that there is already a proposal to allot the land in favor of the library. Situated thus, without expressing any further opinion in the matter, I dispose of the writ petition by setting aside the impugned notice dated 7/7/2012. However, this order would not come in the way of the respondent numbers 2 and 3 in serving a fresh notice upon the petitioners, calling upon them to show cause as to why they should not be evicted from the land by following the due process of law. If such a notice is served upon the petitioners, they be granted reasonable time to present their version and be heard in the matter. It is only thereafter further action, if any, be initiated in the matter by following the due process of law. With the above observation, the writ petition stands disposed of.
Organized.
Due process of law, once you write, earlier due process of law is not written.
Until 8.
Yes, please.
May. My lord, this, we have challenged, my lord, this order of the revenue board, my lord, page 53, order dated 20 of June 2013.
Who is appearing for respondent number 4? You are appearing.
My senior is in another court, Lordship.
Sorry,
My senior is in another court, Lordship.
let him come, but we'll take up the matter and finish it off. It's a old matter, no adjournment. If your senior doesn't reach, you will have to argue. Get ready. Yes, what is the matter?
Yes, ma'am. Madam, challenge this order, my lord, page 53. My lord, the type copy, my lord, operative portion.
No, what is your case?
Yes, my lord.
Hmm.
Yes, my lord, in the Walpada town, my lord, there is one, my lord, Majar, my lord. The Majar, my lord, it is hereditary, my lord. Hereditary, my lord, petitioner grandfather's, my lord, was married there. And my lord, so my lord, there was litigations, my lord, and one last, my lord, that also was filed by one Mohiuddin, grandfather of the petitioner, which is my lord at page 20 and HR 3. My lord, in that case, my lord, right title and interest of the said property, my lord, held in our favor. And accordingly, my lord, land revenue of my lord, revenue record was corrected, my lord. And that order corrected, my lord, and that correction order was challenged in the revenue board, my lord. And revenue board, my lord, modified, my lord, and our humble submission, my lord, as per my lord, observation and direction of the civil suit, my lord, by Munsi, that correction was made. So if the correction was made as per the judgment of the civil court, revenue board should not, my lord, interfere.
Yes.
My lord,
So your client has not challenged the decree passed by the civil court in
My
title
lord,
suit 176.
yes, in the title suit, my lord, 176, page 20.
Yeah.
My lord, suit was decreed, my lord, and precept was issued, my lord. And accordingly, land
So
record.
that decree was not challenged by anyone.
My lord, it is my favor. This degree is in my favor. Page
You
20.
you have not challenged this
No,
decree.
lordship, that was not challenged. Later on, another suit was filed, that was lordship.
So the revenue board can't say that. Revenue board says decree of civil court not binding on the authorities. That's not correct.
No, lordship, as per decree, lordship, they were given 2 kata 10 lesser. As personal Kabarstan, and rest of the lands were given in the name of the.
No, the revenue board says
Lordship.
the settlement officer was not correct in issuing a khatiyan on the basis of civil court's order. That is because civil court may declare right title and interest, but cannot say anything on the question of correction of record.
That is wrong.
That's not
lordship.
correct.
Yes. but
Civil
that is
court
I
will
agree,
issue a precept.
Lordship.
So the reliance is placed on section 154 of the land revenue regulation.
Lordship.
That is another matter. That is when somebody files a suit challenging a entry made in the revenue record.
Lordship.
So this order is illegal.
But lordship, in later part, your lordship will find page 74.
Hmm.
Page 74, status of the disputed land as reveals from the Chita copy has been shown as khas, and in the remark column, possession of Kabarstan. So after proper scrutiny of the factual.
So
and
what I'm
legal-
saying is these matters cannot be decided by the revenue board. These are subject matter of civil suit.
Lordship.
You have to go to the civil court again.
The lordship can direct that if any party agree by any decision, then they can go for civil court. Lordship.
Yes. But we'll have to set aside this order of the revenue board. Because the order is premised on an erroneous foundation.
This order gives the private Kabarstan in favor of the petitioners and the rest of the part in favor of the Anjumane Khademul Islam Waqf property lordship, if they prefers any application for
No,
allotment.
that is okay.
Lordship.
But your client, he has filed the suit,
Lordship.
not implementing your client. The
Lordship.
suit was only against the government.
Yes, lordship.
So be that as it may, the civil court has decreed the suit.
Lordship.
Based on that decree, the settlement officer issues a khatiyan in the name of his
Petitioners.
client
Lordship.
for 2 katas and 10 lessees of land.
Lordship.
The revenue board has interfered with that on the ground that the civil court does not have any jurisdiction to question correction of land record,
Lordship.
right? Or issue a direction to the revenue authorities.
If
That
lordship
is wrong because civil court will always issue precept.
If that suit, if there is a prayer for right title interest by the petitioners, then it is maintainable lordship. If there is no such prayer lordship, then only revenue courts.
Correct, but there was a prayer for right title, declaration of right title and interest.
176, 78 is, there was a prayer
Mhm.
lordship.
So what remains here? We'll set it aside and give liberty to either party to approach civil court.
Lordship.
There is any dispute.
And in fact, lordship.
What
if
is the total
maintain-
area of land? 8 katas.
My lord, my lord, we are confined to 2 kata 10 acres only.
Oh, total area of land. I'm not asking what you're confined to. Total land is some 8. Huh?
8 bigha 1 kata 11 land.
Total land. Total land, total land. Total land.
Page 73, your lordship will find
Hmm.
a plot of land measuring 8 bigha 1 kata 11 and 11 lessa under dark number 113 and 116.
Page 78.
73, second paragraph, lordship. That is the Anjumane Khademul is occupying lordship. Under dark number 113, 116 and 127 of Balijana Circle, Out of the said land, dag number 116 consists of 7 bigha 2 katha of land. So our claim lordship paragraph, third paragraph, on an overall view of claim of the parties, it is crystal clear that when in the name of public Kobostan appellant claiming for 8 bigha 1 katha 11 lesser. Under the 3
Right,
ducts.
I'll come back in 5 minutes. and
Lordship, oblige.
Dictate the judgment.
Lordship. Remember, sir, report lordship which says civil court jurisdiction is barred as per Gwalpara Tenancy Act lordship.
Hmm.
So that stand was taken at that relevant point of time. That was annexed with the earlier writ petition. If your lordship can go through this, or if your lordship
Civil court
allows
jurisdiction is barred regarding what?
regarding lordship correction of revenue record lordship. Under the Gwalpara Tenancy.
So if
Act,
the civil court declares title, then also revenue record will not. Supposing your title is declared,
lordship.
his name will continue in the revenue record. Is that the
Lordship.
law? Huh? Where is that Gwalpara Tenancy Act show me?
And the lordship legal remembrance.
Legal remembrance report doesn't have any binding force in the court. Where is the law?
That Gwalpara tenancy is not with me to the lordship, but I have find it was already in
But
the
I'll not adjourn these matters.
lordship. Then your lordship may dictate lordship.
Anyway, the facts is total, there was 8 bigha 1 katha 11 lesses of land
Lordship.
covered by dag number 116. Then what happened?
3 ducts, lordship.
3 ducts.
113, 116 and 127.
Yes, lordship.
This land was being used as Muslim graveyard.
Lordship.
In
Entire
Gwalpara.
8 bigha lordship,
Gwalpara area.
including 2 katha 10 lesser lordship.
Not including, excluding 2 bigha. Excluding. 2
Our
bigha,
stand
10
is
lesser.
that lordship, including 2 katha 10 lesser.
2 katha 10 lesses covered by which dag?
Dag 116.
Dag 116.
My lord. Decree is paid 23 there.
So the writ petitioner approached the civil court by filing 176 of 78, praying for declaration of title over this 2 katha 10 lesses of land.
Lordship.
Right?
Yes.
But there your clients were not made
No, lordship.
parties.
No,
So
the
civil court passed a decree
lordship.
based on which the assistant settlement officer had
Correct.
corrected the record
Lordship.
and issued a khatiyan in the
Lordship.
name of the
Lordship.
writ petitioner.
Later on, ADC lordship, separate Khotian was issued lordship.
Yes.
And thereafter DC on 13/9/91 created a new dag number 277 in new Khotian number 127.
Right. It is right matter after a correction. Khatiyan issued my lord page 30. The page 30 is the copy of Khatiyan.
That decree was challenged, Lordship,
Decree was challenged.
by the Assam Board of Revenue, but that suit was also dismissed. So thereafter, no.
Decree in civil court was challenged by Assam Board of Revenue.
No, Lordship,
No.
Assam Board of Waqf, as it is a Waqf property, Lordship.
What happened to that?
That was also dismissed. There is annexed H, Lordship, to this writ petition.
So the DC passed an order on 22/6/1990 for correction of record, which was implemented by the settlement officer Gwalpara. By order dated 26/2/2091. Who was the respondent number 2 before the revenue board? Respondent number 2. Who was the respondent number 2 before the revenue board?
No, Anjumana Kadamon is the appeal. Petition of 77.
So it was the Khatian which was put to challenge before the revenue board, is it?
Yes, Lordship.
Huh?
Yes, Lordship.
Who was the respondent number 2 before the revenue board?
Sayyid Mohiuddin was the respondent number 1.
Your clients preferred the appeal before the revenue
Yes,
board.
Lordship.
He was the respondent number 1.
One he and others it mentioned the name is not
Names are not
reflected.
there. And nobody also knows.
Number to 9.
The records are also not there. Record actually. So then we'll have to call for the records. Had Mr. R.S. Chauhan Lanik, had Mr. Chauhan Lanik counsel appearing for the petitioner, also had Mr. Miss R. Chaudhary Lanik, counsel representing the respondent number 4. You are appearing for respondent number
4, Lordship.
4. Ms. G. Hazarika, Lanet SC Revenue, and Mr. N. Goswami, Lanet G. Assam are present on behalf of the official respondents. After hearing the parties at some length, this court finds that the appeal cannot be finally disposed of without perusal of the records of the LCR. Full stop. However, it appears that LCR has not been called by the court. As such, call for the LCR. Let this matter be listed again after the LCR is received. Yes.
Lordship, in the meantime, if your Lordship allows, we can file additional affidavit in opposition.
Parties are allowed to file additional pleadings if so advised. Yes.
Deeply appreciate.
May I please, your lordship?
Yes.
My lord, I am not pressing this petition before your lordship. I may be allowed to withdraw this. Withdraw my
Mr.
petition.
D.K. Kotoki, learned counsel appearing for the writ petition submits that he has instructions from his client not to press this writ petition and therefore the petition be allowed to be withdrawn. Mr. N. Goswami, learned government advocate Assam, and Ms. G. Hazarika, learned SC Revenue Department Assam are present and do not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal.
This is also listed in regular list, manner, hearing list, item of 7. In the hearing. One 162.
Yes, what is the matter?
Matter is manner that we are in, there are 38 members of manor, this small traders in Sonapur Bazaar manor, main bazaar. They are in occupation with 3 kattha, some 18 acres of land. In fact, this land measuring 18 bighas were allotted to Sonapur Sports Association way back in 1987. But we are on the land doing petty measures, the pigeon holes in 3 kattha, 38 members means small. Doing business since 1957 to 60 during their forefathers' time. And that's the only source of livelihood. Now in 2013, there was a threat from the circle officer that you would be evicted because you are in scheduled land. There is a tribal belt land. Then we approach this court, manor. Now, manor, that is my case. And I have given the list of the traders, manor, the petitioners, and they are paying manor revenue also, which is I have annexed for the land. This land was originally manor settled in 1860 with Sonapur Tea Corporation for special cultivation. Manor is a lots of knows manor under section 162, subsection 5 of the Assam Land Revenue Regulation. And we, since the portion of the tea garden has been done away with, and the Digaru Air Force Station came, East Bank of India came, BDO's office came, private government schools came, petroleum came, big bazaar was still there. Then, so we are doing our business. Now, the circle officer filed an evasion counter by response 3. In paragraph 4, he says, he is an extra chitta also. In paragraph 4, he says simply that it is in the tribal belt. He mentions of only one dag number, page number, I think it is 133 in the serial. That the deponent respectively states that as per the record and plot of land covered by the number 111 and FS grant. FS grant means that was granted to Sonapur Tea Corporation. It is a ceiling surplus land mallet now. Number 1 at village Porwabari under Panbari, Mauja, Sonapur, Revenue Circle, Kamrup, falls under the South Kamrup Tribal Belt Public Block. This is the only. But there are 2 darks, my lord. Another dark which is clear from the additional deputy commissioners, affidavit, my lord, is this also paragraph 4, my lord. Here the additional deputy commissioner mentions of the 2 darks. 111 FC grant, Pata number 1 is a Pata land, my lord. And 371 there too, where land measuring 3 katta 15 acres covered by dag number 111 and 371 of village Borwabari so is occupied by the applicants and 38 others by constructing shop as per report of the concerned circle officer Sonapur.
So what are the miss cases for?
Yes.
Yes, what do you have to say? Then give them an alternative place to conduct their business. They are not claiming ownership. If you want, you can ask for shifting, that's another matter. But then where are these people going to go? They are earning their livelihood. Suddenly, because it is tribal belt, you will throw people out. No, we'll pass an order directing that they will be allowed to continue. But if you want to shift them, if the land is required and you want to shift them, then you serve them notice, giving them at least 30 days time and provide them alternative space to set up their stalls. Because this is how it has to go. Suddenly you cannot keep throwing people out from here and there. Where will they go? These are poor people. And they say they have been paying revenue. What revenue?
But it is as per annexes, it is regular revenue.
What regular revenue?
Land revenue, madam.
How can they play land revenue? As what?
It is a Pata-land, madam.
Huh?
Pata-land. And it is already allotted to, this land no more belongs to the government, madam. It was allotted in 1987 to Sonapur Sports Association. Part of that land we are offering. Sonapur Sports Association, lots of kindly mark minor, was settled with, allotted with 18 bighas of land. Out of that, on the boundary of the Sonapur Sports Association, we have a 3 katta 18 acres land where we are doing our business since our time of forefathers, since 1957-60. Sonapur Resources came only in 1987 only, after 30 years.
This land was allocated to Sonapur Sports Association in which year?
1987.
All right, they will have to serve notice here.
And the Sonapur Sports Association is a party.
Party.
Sonapur Sports Association is a party.
But are they represented? Nobody has appeared. So we'll ask them to serve prior notice, giving description of the land. And if it turns out to be Sarkari land or land in tribal belt, then they will have to provide alternative arrangements. But Mr. R.P. Sharma,
if they desire to, one thing.
right.
If they so desire to evict us.
R.P. Sharma, learned senior. You are appearing?
Yes.
For
the private respondent.
What do you have to say?
Lordship, our respondent submission is that they have been illegally occupying, Lordship, in spite of the fact that they were.
But they are occupying land belonging to your client.
Yes, Your Lordship.
Then it's a private land.
Lordship.
Then Pata land.
Lordship.
Pata land, how do you?
It was earmarked for the association, Lordship. It meant it was allotted to the Sonapur Sports Association, Lordship. They were.
Let them follow the due process of law. Orally, they cannot evict someone.
Lordship.
Mr. R.P. Sharma, senior counsel, listed by Mr. R. Sharma, is it?
Yes. Yes.
R. Sharma, learned counsel appearing for the writ petitioner. For the writ petitioners, also heard Ms. G. Hazarika, learned SC Revenue Department, Assam, appearing for respond number 1, Mr. N. Goswami, learned G. Assam for respond numbers 2, 3, and 4. Mr. A. Ganguly, learned counsel is present on behalf of the respond number 5. First up. The 3 writ petitioners herein are running their daily business from the sheds, SHEDS sheds in the newly constructed Sonapur Khudra Vyavasai Santha market located at Sonapur, so as to earn their livelihoods. Full stop. There are only 3 petitioners. Why do you say 38? There are only 3 petitioners here.
No, my lord, because this registered organization, my lord, it is petition filed in Sonapur, Khudra Vyavasai Santha. List we have annexed already.
Achha, you write, change it, so and so, right. The writ petitioner number 1, namely Sonapur New Market Khudra Vyavasai Santha, is a registered society of petty businessmen operating their shops from the aforesaid market, and the petitioner number 2 is the who are petition numbers 2 and 3? Petitioner numbers 2 and 3.
Nayanjyoti Burman.
Yes, I have seen. And next is Akib Ahmed. I'm
Yes.
asking who are they?
They are the members of the association.
And petitioner numbers 2 and 3 are the members of the petitioner number 1 association. As per the case projected in the writ petition, the petitioners are running their shops from the sheds located in the aforesaid market for earning their day-to-day livelihood. Full stop. However, according to the petitioners, on 18/11/2013, the revenue authorities have threatened to evict them, orally to evict them from the sheds under their occupation on the ground that they are occupying land falling in tribal belt. Full stop. Mr. Sharma submits that the land in question, Mr. Sharma, learned senior counsel for the petitioner, submits that in the year 1987, around 18 bighas of land was allotted in favor the respond number 5 by respond number 5, that is the Sonapur Sports Association, by issuing only in accordance with law and after serving prior notice to the individual members of the petitioner number one society, giving them at least 30 days time to vacate the respective sheds. Full stop. The respondent numbers 2, 3, and 4 to also consider the request. In such event, the respondent numbers 2, 3, and 4 to also consider request, if any, made by the members of the petitioner association for providing them with alternative location for conducting their day-to-day business. Full stop. Until such time, the aforesaid conditions are met, the respondents shall not interfere with the operation of the daily business of the petitioners. Read petition stands disposed of and all other connected matters stands disposed of.
Obliged.
Where to complete one.
Item 11 and 12.
Now, second action is according to issued the road permit to the petitioner. That is on 17/2/2014. Now, thereafter petitioner by dated 22/14 confirmed the performance payment for transportation of the gold coins from Kottayam to Guwahati. According to performance payment states of the same consignment to Gate Airways and the Gate price. The petitioner tried to make the online declaration of the consignment brought from the state of Assam to Assam state of Assam on 22/2/2014 itself. But as the user encountered below sensitivity problems, the said whether online declaration was made on 27/2/2014. Now, the consignment reached Guwahati on 26. After the arrival of the state consignment, a notice was issued under section 75, 12A of the Assam Radar to the in charge performance of the Gate Airlines Europe to produce the papers, reports, and documents, including the delivery note, road permit, transit passes, consignment note on the same day. The representative of the performance must produce the road permit as well as all documents and papers in support of consignment, but the responsibility sees the said roads for alleged failure to produce the proper evidence in terms of online declaration in support of the consignment of the goods. On a petition on your 3/2014, informed the responsibility that the said documents were purchased by GS Bank Tegara. Inform the responsibility that the online declaration was also completed on 27/2/2014, well before the time period of the 3 days from the date of arrival of the said materials, as per the memo number so and so dated so and so. The additional papers therefore requested that the petition therefore requested for release of the said goods and so and so. Goods, whichever is a letter, the traders shall also obtain and use the statutory forms like delivery note, road permit, as the case may be, as statutory required in such transport.
Yes.
Now, in the present case, my lord, before taking the delivery goods, the online declaration was already made. And not only that, all the delivery notes, papers, etc. documents, all were produced before the authorities. And the declaration form below, in that declaration form, it was clearly mentioned that we are importing the said goods. And accordingly, the delivery note was issued. You'll also find that below at page 38, 28.
28, my lord, is a letter addressed to the Supreme Taxes. Against the above mentioned subject, book kindly issue us one road permit for bringing gold coins from the Kolkata office located in so and so. The said gold coin will be delivered to the HDFC Bank Limited at Kolkata office as per the pro forma invoice enclosed herewith for your reference. And also find page 29. The pro forma invoice was there. This was on 17/2. And the pro forma invoice you'll also find page 30. And page 30, my lord, the delivery note was issued to the petitioner. By the assessing authority on 17/2/2014.
What is this in page 30? Is it pro forma invoice?
No, this is page 30 is the delivery note. I'm sorry, my lord, page 29 is the pro forma invoice. Page 30 is the delivery note which was issued by the assessing authority. You'll also find the delivery note at page 30, quantity 707 pieces gold coin, amount, and the name of the transporter, everything is mentioned there below.
Where is the impugn order?
Below the impugn order, you also find the first so-called notice was issued, seizure was made below at page 34.
So these are not appealable.
My lord,
The seizure orders and orders imposing tax penalty are not appealable orders.
below the seizure order is not applicable, my lord. Order of seizure.
And the order imposing penalty?
But this is not order imposing penalty. For the release of the goods, you have to give it. I will show you, Lordship, my lord. I am telling you the very, my lord, the order of seizure also, and this honorable court also, division bench has also dealt with it. Because the issue is that it can be seized only when there is an intent to evade the payment of tax. Now, once I have disclosed it before the Supreme Taxes, the taking the delivery note from him, where is the question of the attempt to evade the payment of tax? And your lordship, you have another Hindustan Steel case, the Supreme Court said for the technical breach, something, the penalty cannot be imposed. If I have disclosed to everything to the assessing authority, I have taken the delivery note, informing him that this is the gold I am bringing, and accordingly the delivery note was issued. I have informed in advance to the assessing authority, and he has issued the delivery note. Where the question of the evasion of tax, attempt to evasion tax, and the Commissioner of Taxes also said, because gold and all these are precious materials, so within 3 days of the arrival, you can make the online entry. Now I made the entry on 26th, it received 27th itself. I made the online entry also. There is no question of fulfilling the provisions of the Act. Unless and until there is attempt to evade the payment of tax, where is the question of the seizure and the consequential demand of the tax or penalty.
Yes, please proceed.
Now, if you also looks into the section 75.
75 of
Assam value tax, Miller. I'll give the book, Miller,
you
extra.
have not given the books of list of books.
Then I'll give the extra book, Miller. You want the section of 756.
Yes.
You'll also see 75/6 below. At page 491.
491.
My lord.
Yes.
May I read, my lord? The officer detaining or seizing the goods shall record the statement, if any, given by the owner of the goods or representative or the driver or any person in charge of the vehicle. If after the inquiry, including an inquiry into the nature of the transaction, which occasions the movement of the goods, and the officer finds that there has been an attempt to evade the tax under this act, he shall, by an order imposing on the owner of the goods, and in case the owner not forthcoming, which is identity is not disclosed by the person in charge of the goods or the driver or person in charge of the vehicle in which the goods are being carried, on the person in charge of the goods or vehicles or the driver deeming such person to be the owner of the goods, a penalty equivalent to calculated the value of the goods at 3 times of the rate of the applicable to such sale or purchase of goods, and direct him to deposit, in addition to the penalty, advance tax calculated on the deemed sale value of the goods at the applicable rate of tax on the sale of such goods, which shall be below adjustable with the liability of the tax incurred on the purchase or sale of such goods or the sale of goods manufactured therefrom, and in case you find otherwise, he shall release the goods. Prior to that, you'll also see below subsection 5. If on examination of the contents of the goods vehicle or the inspection of the records relating to the goods carried, the officer in charge of a checkpost or a barrier or person empowered by the commissioner in this behalf has reason to believe that the owner or the person in charge of such goods vehicle is not carrying the documents as required by the subsection 3, or is not carrying proper and genuine documents, or is attempting to evade payment of tax due under this act, or that the sale or purchase of goods for the purpose of tax under this act has not been properly accounted for, he may, for reasons to be recorded in writing, seize the goods and documents relating to goods and for documents of the vehicle. So, my lord, the satisfaction must be there, my lord, that he is attempting to evade the payment of tax. Now, a person who has declared the same prior to the arrival, 10 days before the assessing authority, that I am bringing such goods, kindly give me delivery note, and the delivery note has been given, and all the papers and documents have been given, and only on the ground that the online declaration was not made, without looking into the circular, the qualification of the commissioner, that in case of the gold, etc., all these things, you can make the declaration within 3 days of the arrival. Now, the declaration having been made 26th, before taking the delivery of the goods, the declaration was made. Now, under such circumstances, can it be said, my lord, that there was any attempt to evade the payment of any tax by the SEC to empower the authority to seize the goods and to demand the tax and penalty? Lordship, may I see the order?
Yes.
At page 70, my lord, page 34. First is the, my lord, for the purpose of examination, my lord, page 34. Whereas it will become expedient to make a check of the consignment of taxable goods being carried by you to ascertain the proper accounting of such consignment to our tax level of Assam, you are therefore required to produce or caused to produce all papers, documents, include delivery note, transit passes, consignment note before the undersigned. That was to the Lord Jet Airways. Now, thereafter, at page 35, the Jimma was given to the Jet Airways. Now, page 36 is the seizure. And Lordship, see the regions, grounds of seizure. The party failed to produce upon notice proper evidence in terms of online declaration in support of the consignment of the taxable goods subject to seizure, which is according to leading to evasion of taxes under the Assam Value Tax Act. Lord, how when the consignment note, when the delivery note, when all other documents have been given, how the online declaration which is made, which was made before the delivery of the goods, can be said to be that there will be evasion of tax? And it says which is leading to evasion of tax. And the words are, my lord, that there must be an attempt to evade the payment of tax. Now I am asking a question, Mr. Miller, how there can be an attempt to evade the payment of tax when everything is disclosed to the assessing authority? Much before. And when the Commissioner of Taxes himself has said that in the case of gold is extra, all these things, the declaration, online declaration may be made within 3 days of the arrival of the goods. Thereafter, my lord, the notice was issued to me, my lord, at page 45. To pay the advance tax and the penalty for release of the goods.
So payment of tax, you don't have any problem.
For payment of tax, there will be no tax at all unless until the sale is there. There cannot be tax. I brought these gold coins for distribution among my distributors, various distributors. And once the sales takes place, then only tax will be there. When the goods are imported, my lord, from outside, I have to make a declaration that yes, I bought these goods, so that it will be accounted for. The assessing authority will examine at the time of assessment whether these goods were bought from outside.
So for importing, you have to pay import duty.
No import duty, my lord.
Then?
From Calcutta, there is no import duty.
No. Somebody has brought it from outside the country.
Outside there will import duty. But
So from Calcutta to Guwahati, there is no tax.
No tax.
Because there is no point of sale.
No. I purchased in Calcutta, and from my head office to the branch office it was sent. Assuming, my lord, it was purchased from Guwahati to Calcutta directly, interstate sale, then the CST would have been there. But at that CST also, there will be no evasion in Assam because that will be taxable only in Bengal. But in my case, they were not so because I purchased in HDFC Bank in Calcutta, my head office. And after taking delivery of the goods, I directed by the transporter to deliver it to my branch office at Guwahati. So there is no question of any tax here in Assam, evasion of any tax, question of attempt to evade anti-bank tax. Attempt to evade payment of tax, there's some malicious intention. Something must be there that he wants to evade. But when the everything has been disclosed to the assessing authority, he has given me a delivery note. And delivery note means, it remains a record that what you have imported from outside, so that the assessing authority can verify that subsequently that what is the ultimately you have done to the goods. The judgment was division bench. Hindustan still.
So basically the impugned order is 6/3/2014, is it?
Well, I have to, in fact, I was forced to make the payment by demand draft because the goods were not released. I have to distribute to my distributors. So I have no alternative. I gave a letter that I have no other option but to get the goods released.
So you paid the penalty of 8,38,000
by demand draft.
By demand draft.
My lord.
And now the goods have been released.
Released.
So now you are questioning this if you succeed.
The refund of the
question is
tax and
refund.
penalty which has been imposed. Because there is a provision, my lord, that the seized goods can get released either by giving a bank guarantee or by payment. And they insisted that you, unless and until you give demand draft, we will not release it. 76(6) says, my lord, that it can be released Lordship find page 46. I wanted to give a bank guarantee, which was later was received also. Your Lordship received page 46. That we are ready to give the bank guarantee for the release of the goods. But this was received also by the assessing authority. And thereafter, after received, this letter was returned to us. That no, you have to give the demand draft.
What was the total penalty? 11 lakhs.
Penalty and the interest, a tax.
So this is the amount your client actually paid by DD.
Well, now we'll also kindly see the judgment of the Supreme Court in Hindustan Steel.
Yes.
Para 8, my lord.
Yes.
Under the Act, penalty may be imposed for failure to register as a dealer. Section 9(1) read with Section 25(1) of the Act. But the liability to pay penalty does not arise merely upon the proof of default in registering as a dealer. An order imposing penalty for failure to carry out a statutory obligation is a result of a quasi-criminal proceeding, and penalty will not ordinarily be imposed unless the penalty party applies either acted deliberately in defiance of law or was guilty of conduct, contumacious or dishonest, and acted in a conscious disregard of his obligation. Penalty will not also be imposed merely because it is lawful to do so. Whether penalty should be imposed for failure to perform statutory obligation is a matter of discretion of the authority to be exercised judicially and on a consideration of all the relevant circumstances. Even minimum penalty prescribed, the authority competent to impose the penalty will be justified in refusing to impose penalty when there is a technical or venial breach of the provisions of the Act, or when the breach flows from a bona fide belief that the offender is not liable to act in a manner prescribed by the statute. These in charges of the affairs of the company in failing so and so. Now, in this case, my lord, I acted on the basis of the circular, the meeting which was held by the commissioner. And there cannot be any attempt to evade payment of tax because everything was declared. Now, we'll also kindly see the division bench judgment of this honorable court.
Yes.
The same, my lord, on the ground of the not making the online declaration. I'll also see paragraph 9, my lord. I'm reading, my lord.
Yes.
My lord. In that circumstance, it would be necessary to take note of the remaining contentions. In the instant case, the fact that the petitioner had not uploaded the documents in the electronic mode is not in dispute. Yet the issue would be as to whether the documents which are required to accompany the goods as provided under rule so and so of the rules was available along with the goods, and whether the documents subsequently tendered along with the reply were genuine documents and which were in existence simultaneously at the point of time when the goods were dispatched. To that extent, a perusal of the seizure list would indicate a common ground for seizure relating to 3 items in goods, which were item number so and so belongs to the petitioner. The common ground observed is that the person in charge of the transported goods could not produce proper and genuine documents which were required as by the act of so and so. There is no specific indication with reference to the different items the goods seized. In that background, the communication referring to the seizure and asking for the relevant documents from the petitioner for verification would be relevant. In respect of the same, the petitioner through the communication has mentioned to the documents which the claim accompanied the consignment. However, through the ordered sheet and the proceeding of the Supreme Taxes, the indication is that the transporter had not made online declaration of the consignment, which presently is the non-compliance of Rule 5 of the Rule 41 of the 2000 Rules of 2005. The same also indicates the dealer is therefore asked to show cause why taxes and penalties should not be imposed. Subsequent thereto, the order dated so-and-so only at past therein indicated that the petitioner had made an online declaration on 16/12/2013 after 5 days after the arrival of the goods on 10/12/2003. The same is considered as a lapse and it concluded that the dealer seems to have attempted to evade the tax payable under the act. It is in this view, though the order dated so-and-so, the inspector of taxes has proceeded to impose the penalty at 3 times the tax which is levied by the Supreme Taxes. Neither the order nor in the order dated so-and-so a specific reference is made to indicate that the document submitted in the physical form was not sufficient to satisfy the authorities about the compliance and as to whether even in that circumstances there was any attempt made to evade taxes. From the perusal of the said orders, it appears that both the authorities, namely Supreme Taxes and the Inspector of Taxes, have arrived at their conclusion merely because the documents were not uploaded in the electric format. Though sub-rule so-and-so provides for uploading the documents in electric format, the non-compliance of the same does not indicate any consequence, nor the circulars issued in this regard is specified in consequence for the non-compliance. The circular only indicates the case which the checking would be completed at the checkpost. In that background, when penalty is to be imposed for non-compliance of the requirements of the production of documents provided in the rules so-and-so, and when presumption of evasion of tax is debatable by production of the documents, the authority were required to apply their mind to this respect to the matter. In that regard, the documents as referred to by the petitioner in reply were to be examined and find out whether the said documents were genuine and whether the documents were in existence on the date of movement of the goods. In that regard, if the authority was satisfied, the documents in the physical form were available on the date of the movement of the goods. In that event, a consideration was necessary to be made as to whether the penalty was leviable only because the uploading of the electric form was necessary. In the instant case, no such exercise was done, but penalty has been imposed only on the observation that the online declaration has not been made insofar as the tax levied so-and-so is so-and-so. Now, in this case, my lord, you'll also find in the order of seizure as well as there, the only ground which has been given that online declaration was not made. Whereas the satisfaction which was there that on the basis of documents and papers, whether there was an attempt to evade payment of tax. Now, it is not.
Mr. Gogoi, you have the records.
Records, there is not available.
Court would like to see the records. Can you get it second half?
Today, it will be, let it be day after tomorrow in this case, only on this point, ma'am.
Day after tomorrow?
Kohima. There is some matter in the Kohima day after tomorrow.
Tomorrow, in that case, tomorrow, in a second.
Tomorrow.
Yes.
Take down her, Dr. K. Sarab, Learned Senior Counsel appearing for the Writ Petitioner on the request of Mr. B. Gogoi, Learned SC Finance and Taxation Department. Assam. This matter is directed to be listed again as a fixed parted matter tomorrow, that is give the date, so as to enable Mr. Gogoi to produce the relevant departmental record.
But the next case also reports may call that you on the same issue.
Along with item?
Both the cases.
Item 1.
I'm obliged.
Okay, it will last.
Yes, Lordship wanted to know about that 144 order, which is in existence presently. So that order I have taken a copy.
6th August.
This is not even legible, but it shows that it is 8th of June 2022.
Yeah. It is for border area.
This is 8th of June. Then again, another one. These continuous orders of 144 keeps on coming one after another. There isn't any gap between the two. Then again, another one order comes in 9/8/2023. I think I also gave a copy of it. Yes.
So
And that apart,
all meetings are stopped in Jorat.
no, not meeting. And in fact, specifically as regard the petitioner's case, already he has enclosed it as a part of his record. If we go to annexure number 4, annexure number, sorry. Annexure 6, page 43. The Ms. J case has been filed restraining the petitioners and the people from assembling and changing the name of the society from the erstwhile previous name. So presently, they are being named as the Bihari Thakurbari Kali Mandir Samiti. Earlier, it was known as Hindustan Panchayati Thakurbari and Kali Mandir Samiti. So this restraining petition has been filed and accordingly order has been passed to that effect. If your lordship goes to the last part of page 45.
So they said they will comply with the order of the civil
We are not going to violate that order. We are not going to violate that order. How government?
No, it is not with regard to government. It is with regard to law and order, because 500 and odd people are going to assemble in the meeting. That's what has been told by them. Previously, their application was only for general meeting. In the subsequent application, again, the representation, they says that we are going to discuss about this present title suit. So they have two different agendas as regard holding the meeting. They are not clear about what exactly they.
Mr. Borua, you see, they want to hold the meeting. If there is a restraint order from the court not to hold the meeting, then it is understandable. Otherwise, on what ground will you deny them permission? This is a society and they want to hold their meeting. That's
So that for that matter, I have to take to this order. Thus, considering the above and without going into the merit of the case, this court is inclined to allow the prayer of the petitioner to the extent that ex parte injunction against the opposite party, restraining them from holding the general meeting of the society with the agenda of changing the name of the opposite party number 1. In the light of the above, the defendant opposite party are directed not to hold the general meeting with the agenda of changing the name of the defendant opposite party number 1, that is Sri Bihari Thakurbari and Kali Mandir Samiti, or for restoring of the old name on 23 and until further order of this court. So this matter is pending. It is fixed for objection hearing. Let it be decided by the civil court. If at all they are being allowed, definitely the administration will not come in.
When is it fixed?
Next date is fixed somewhere in this month. When there is a restraint order.
No, Mr. Das, there is a civil court proceeding here.
Yes.
No. Lordship can say directed not to hold a general meeting with the agenda.
Get a leave of the court to hold it without the agenda. And
Yes. The agenda of changing the name. We are not going to do that, man.
It's clear.
You have to get the leave of the court that we will, whoever wants to hold the meeting.
Yes.
Listen, there is a proceeding pending before the civil court
Yes.
where there is a live issue pertaining to holding of the meeting. The entire proceedings are not here before the court. So the writ court cannot take a view this way or that way.
Yes.
So the SP also says that this is something to do with the civil court proceeding. Now, you may be right in saying so, but you have to get that clarification from the civil court.
Yes.
Lordship may dispose it of a direction that the civil court may clarify or seek clarification for holding of the.
Seek clarification and accordingly proceed and subject to such clarification.
They are at liberty to approach it.
Seek clarification as
All right, heard
holding of
Mr.
general meeting.
Vidikas, learned senior counsel, assisted by Mr. S. Bora, learned counsel appearing for the writ petitioner. I have also heard Mr. S. Borua, learned government advocate Assam, appearing for the Respondent numbers,
Yes,
all the respondents appearing for the respondents. Full stop. The petitioner herein, the petitioner numbers 1 and 2 herein claim to be the members of what?
Bihari Thakurbari Kali Mandir Samiti.
Bihari Thakurbari and Kali Mandir Samiti, Jorhat, which was earlier known as
General Secretary and Working President.
claims to be the secretary and working president, respectively, of the Bihari Thakurbari and Kali Mandir Samiti, Jorhat, which was earlier known as Hindustani Panchayati Thakurbari and Kali Mandir Samiti. Full stop. It appears that the petitioners had sought permission of the district administration for convening the AGM of the society. But
As per section 4 of the society's registration.
as per section 4 of the Societies Registration Act 1860,
My lord,
uh,
which demands, my lord, that every year a meeting should be held.
But at the same time, not sir, but they haven't got the registration certificate as yet.
No, we have.
however, according to Mr. Das, no permission has been granted till today, as a result of which the AGM of the society could not be held till today. Full stop. Mr. Borua, learned government advocate Assam, has obtained instruction from the concerned authorities in terms of the earlier order dated 38/2023 passed by this court, and submits that that apart from the fact that section 144 CRPC is in force in the district of Jorhat with effect from 9/8/2023, there is also a civil proceeding pending before the court of Munsif number 1 Jorhat in the form of title suit number 50/2023, wherein there is an interim order of injunction dated 27/2023, passed in Miss J case number 41 of 2023, which is holding the field. Full stop. Mr. Borua submits that as per the ex parte order of injunction, there is a restraint upon the petitioners and other members of the society in holding a general meeting of the said society on the agenda of changing the name of the society. And therefore, unless the said issue is resolved, holding the meeting would amount to acting in violation of the order of the civil court. Full stop. From the materials available on record, I also find that there is a civil suit pending before the learned Munsif number 1 Jorhat, wherein the aforesaid issue is the subject matter of the suit. First of, under the circumstances, if the petitioners want to hold the AGM of the meeting by adopting the name as projected in the writ petition, that would certainly amount to violation of the order of ex parte injunction.
No, that will not violate. That will be in favor, my lord. That is also that
That
Thakurbari.
would certainly have a bearing in the pending proceedings before the learned Munsif number 1. Full stop.
Yes.
Although Mr. Das has submitted that his client would not violate the order of the civil court if the meeting is permitted to be held, this court is of the opinion that since there is already a proceeding pending before the learned civil court, the petitioners must approach the court below and seek leave to
For
hold the
clarification.
meeting and or obtain clarificatory orders. First of, as such, granting liberty to the petitioners to approach the learned civil court by filing appropriate application stroke objection as may be permissible under the law. This writ petition stands disposed of. It is made clear that if the petitioners approach the court seeking leave to hold the AGM, the said prayer will be considered objectively and dealt with by an effective order to be passed as expeditiously as possible. In the event the learned civil court grants permission to the petitioner to hold the AGM on the terms and conditions as may be deemed fit and proper, the district administration will facilitate holding of the AGM in accordance with law. Read petition